Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. In this video, we're going to be dealing with legal capacity. But before we get started, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. I also wanted to let you know that the video also has timestamps. And if you're on a laptop or computer, if you're looking at the video, you'll see at the bottom of the video there's a broken line there. And every time you go to a certain portion in the broken line, you'll see that it's a specific topic. So you can use that to skip to different topics on the video. Or if you're also on your computer or laptop or on your phone, you can go to the description. And the way to get to the description when you're on your laptop or computer is to go to show more, scroll down from the socials, you'll see the time codes. If you're on your mobile, just press the arrow button and it will show you the description. You also scroll down until you get to the time codes, and then you just press on the blue portion on the time codes and it will take you to that particular time and topic on the video. In dealing with legal capacity, we are going to be looking at natural persons, companies, partnerships, trusts, associations, or societies. And we are going to be looking only at their ability to enter into contracts and the ability for them to sue or be sued. Natural persons. Every natural person is born with legal capacity. However, that legal capacity can be limited. The limitation could be because the person is a minor, because the person is suffering from a mental illness, because the person is a prodigal, or they are insolvent. In dealing with whether or not a person is a minor, we have to look at the age of majority in Botswana. The age of majority used to be 21. But it was then reduced to 18. So when we are talking about minors, we are talking about people below the age of 18. However, the law says even people below the age of 18 can be divided into two categories. And these categories are based on whether or not this minor is responsible and is able to understand to a certain extent the impact of their actions. Usually children below the age of 7 are considered to not have the ability or responsibility to understand these actions, such as entering into a contract or suing or being sued. Therefore, can only act through their parent or guardian. The parent or guardian is the one that enters into the contract for and on behalf of the minor, and the parent or guardian is the one that sues or is sued for and on behalf of the minor. In respect of those 7 years and above, they can enter into contracts, they can sue or be sued with the assistance of the parent or guardian. They cannot do it by themselves. One of the exceptions to this rule is if a person is emancipated by the courts. And emancipation is where the court says, even though you are below the age of 18, we will start to recognize you as an adult. And the court will make that order based on various factors that it would be looking at. Another limitation on capacity is a person who suffers from mental illness. A person who suffers from mental illness has to be declared as suffering from mental illness by the court. However, just because a person is declared as suffering from mental illness by the court doesn't mean that that mental illness only starts operating at that time. An example, if a person started suffering from mental illness in 2018 and they're only declared as suffering from mental illness in 2020, if one is able to demonstrate that they entered into contracts between 2018 and 2020 and that they were sued or they sued between 2018 and 2020, then these are set aside because during that period, this person still suffered from mental illness even though they hadn't yet been declared as such by the court. A person who is declared as suffering from mental illness does not have the capacity to enter into contracts, and they don't have the capacity to sue or be sued. When the court declares a person as suffering from mental illness, they appoint what is called a curator bonus to manage the affairs of this individual. And this curator bonus is the one that enters into contracts for and on behalf of the person who suffers from mental illness. And he or she is the one that sues or is sued for and on behalf of the person suffering from this mental illness. The person who suffers from mental illness cannot be said to be assisted by this curator. They do not have the capacity even to be assisted, and that is the reason why the curator is the one that acts for and on their behalf. The other limitation to capacity could be the inability to manage one's affairs. And this inability could be due to physical disability or impairment or mental disability. Now, when dealing with mental disability, there must be a distinction drawn between mental illness and mental disability. Mental disability in this instance means a person who is able to function to a certain extent, even with this disability. This is also true in respect of people suffering from physical disability. An example of this is people that might be suffering from depression. Depression might incapacitate a person to the point that they are not able to function for extended periods of time. However, there are instances where they are able to act from time to time. Those are the examples of mental disability. Similarly, it could be the same in respect of physical disability, where a person is in hospital, for example, and they are not able to manage their affairs. Although they are not in a coma, they are in touch with all their faculties. However, because of this disability or incapacity of being at hospital for an extended period of time, if a person has been involved in an accident and they become disabled and they are not able to function for a certain period of time, or they need assistance for an extended period of time, then this person can be declared as suffering from a mental or physical disability. And the court would also have to appoint a curator bonus for this person if someone is able to demonstrate that this person suffers from this issue of not being able to manage their affairs. If that's the case, then this person can act with the assistance of a curator. This is different from a person who suffers from mental illness where the law says they cannot act. In order to have a person declared as suffering from mental illness, having a physical disability or mental disability, there is an entire process set out by the courts, particularly the High Court, that have to be met to satisfy the court. If you have a person who you want to have declared as suffering from a mental illness, having a physical disability, or a mental disability that makes them unable to manage their affairs, please engage the services of an attorney so that the attorney can explain to you the necessary process that has to be followed. The reason why this is important is because when a court declares a person as having limited capacity, they are effectively making this person become somewhat of a child. And if this person is an adult, the court is very slow to interfere and remove these capabilities. A person's capacity can also be limited if they are what is considered to be a prodigal. A prodigal is a person who is unable to manage their affairs, particularly their financial and economic affairs. A distinction must be drawn between a person who cannot manage their affairs because of a physical or mental disability and a person who is a prodigal. A prodigal is a person who has their full mental faculties and has no physical disabilities, but however cannot manage their financial and economic affairs because an example could be that they are alcoholics or that they are addicted to gambling. In that instance, this person starts to use their money and assets in a reckless way. A person has to be declared to be a prodigal by the court. A person who is declared to be a prodigal by the court will have a curator bonus appointed for them. And this person, before they are declared a prodigal, can sue and be sued directly, and they can enter into contracts. And if a person who is declared a prodigal entered into a contract before the declaration of them being a prodigal, then that contract is considered to be valid. However, a person who is a prodigal, once declared a prodigal, has to contract with the consent of the curator and can sue and be sued through the curator or with the consent of the curator. If a person, knowing that they are prodigal, having been declared so, tries to enter into contracts without the consent of the curator, then the curator can sue that person for contempt. And one of the things that they can ask for in suing for contempt is that the prodigal be imprisoned. And imprisonment might be seen as a way in order to teach this prodigal that they cannot deal with their finances without the assistance and consent of the curator. However, the court, in all contempt proceedings, not just those dealing with prodigals, is very slow to put people in jail. Once the curator has been appointed to a person who is said to be a prodigal, then that person has lost the ability to contract by themselves, and they cannot sue or be sued directly. A person who sues or is sued by a prodigal, this action is taken through the curator. A person is declared to be a prodigal not for their own protection, but for the protection of their family members and innocent third parties. The next limitation on capacity is insolvency. A person is said to be insolvent if they are declared as such by the court. And an insolvent person is a person whose debts are far more than their assets, and they are not able to pay those debts. A person who is declared to be insolvent has to be looked at as a whole. And when I say as a whole, I mean that a person who is declared as insolvent could be in a partnership. And I will be dealing with partnerships later on in this video. If they are in a partnership, then the assets of the insolvent person, the assets of the partnership, as well as the assets of the innocent partners or non-insolvent partners are attached as part of the insolvency. In order for this to be stopped or prevented, the partner or partners that are not insolvent can advise the court that they will pay these debts of the insolvent person within certain timelines that can be agreed. Insolvency is dealt with in terms of the Insolvency Act. And the Insolvency Act goes further to deal with insolvent people who are married. Insolvent people who are married also have the same situation in respect of partnerships. The property of the insolvent partner and the spouse will be taken as part of the insolvency estate, especially if the spouses are not separated by the court, what is known as judicial separation, or the separation is not done by way of notarial deed as provided for in the Insolvency Act. And the Insolvency Act makes no distinction about whether or not these people are married in or out of community of property. However, one issue that is considered in dealing with this particular situation, especially where the people are married out of community of property, is whether or not the assets of the non-insolvent spouse were bought through the proceeds of the actions of the insolvent person. An example is if the insolvent person got a loan with a bank and used that money to buy their spouse a car, and the car is registered in the name of the spouse. If they're married out of community of property, one could argue that that car then becomes the asset of the spouse. However, in dealing with insolvency, because he took this liability and the spouse benefited from this liability through the car, all the assets are pulled together. A person who is declared insolvent has the ability to enter into contracts or sue and be sued only through a trustee that is appointed by the master to deal with the insolvent estate. The insolvent cannot act by or for themselves, especially in situations relating to money. However, prodigals and insolvent people can sue or be sued without the assistance of their trustee or curator if the matter is a divorce matter, as an example. Or in the example of a prodigal or an insolvent, if they want to enter into a contract to work or become employees, then they don't necessarily need the assistance of the curator or trustee. However, it is always best for the curator or trustee to be involved in all matters where the prodigal or insolvent could incur legal costs or incur liabilities. Now we are dealing with companies. When a company is created, it is considered to be incorporated. And once a company is incorporated, the law creates what is called a corporate veil, because a company is considered to have its own legal capacity. In other words, a company is considered to be a legal person. This means that a company can enter into contracts in its own name, and it can sue and be sued in its own name. The assets of the company are separate from the assets of the owners of the company. And if the company has liabilities or debts, these liabilities or debts do not go to the owners. This is the general rule. However, if a person is able to demonstrate that the reason why the company is suffering or not doing well is because of the way the owners or directors were running it, then they have to convince the court that it should pierce the corporate veil and hold the shareholders accountable. A company can also be declared insolvent, similar to a natural person. There is an entire process of having a company declared as insolvent, and where it is a company that is declared as insolvent, it is said to be a company under liquidation. A company under liquidation has appointed to it by the master of the High Court a liquidator. The liquidator steps into the shoes of the owners of the companies and directors, and his main function is to be able to pay off the debts of the company. And he does so through the liquidation process. However, in this video, we're not dealing with the liquidation process. After companies, one looks at partnerships. Partnerships are where 2 or more people, but less than 20, enter into an agreement, and this agreement is for them to make money. The partners in a partnership have to bring something to the partnership. What they bring to the partnership could be in the form of labor, skill, or even money. A partnership can enter into contracts, sue or be sued in its own name. However, a partnership has no separate legal personality from the people in the partnership. This means that If a partnership owes money, let's say 100 pula as an example, then it means the partners together owe 100 pula. If they are not able to pay this 100 pula, then the person or bank that they owe can attach the property of the partnership or the property of the partners themselves. Similarly, if one person in a partnership acting on their own gets into debt, then that debt attaches to the partnership and the partners as well. So if you have 3 partners, partner A, B, and C, and partner A in their personal life goes to the bank and gets a mortgage of 1 million pula. If they are not able to pay that mortgage, then the bank will go after partner A, partner B, and partner C. This is true whether or not partner B and C even knew about this loan. Meaning that even as you sue or are sued as a partnership in the partnership's name or enter into contracts in the partnership's name, the people that are responsible and have the duty to ensure that everything is done right are the partners. As previously explained, if a person who is in a partnership is declared as insolvent, then the assets of all the partners form part of the insolvent estate. Unless the other partners who are not declared insolvent are able to pay off the debt of the insolvent partner within timelines either set by the court or agreed with the trustee. The next issue to discuss is trusts. Trusts also do not have a separate legal personality. However, trusts are very peculiar in that trusts are separate estates from the estates of the trustees. And every trust, once created, can sue and be sued in its own name. And by extension, it can contract in its own name. However, when a person sues a trust, they must also sue the trustees. And that is because, like I explained, a trust does not have a separate legal personality from its trustees. Trusts are a very specialized area of law, and they require specific discussion into the rights and duties of the trustees, the beneficiaries, and on what happens if a trust has a debt that it cannot pay. And I will deal with trusts in videos later on in this channel. After trusts, there are societies or associations. And societies and associations are created under 2 types of law. They can be created under statutory law, which is through acts of parliament, or common law, which is the law inherited from South Africa by Botswana. There are voluntary associations, which is what we are going to be talking about in this video. When you look at statutory law, these voluntary associations or societies can be created under the Societies Act, the Cooperative Society Act, and Building Society Act. Associations or societies created under common law or under the Societies Act do not have separate legal personality from its members. And in order for a society or association to be considered as such or registered, it has to have 10 or more people. In order for an association or society to have a separate legal personality from its members, it has to meet 3 requirements. First requirement is that it must have perpetual succession. This means that even as the members come and go, the association or society still exists. The second requirement is that it must be able to own property. And this property could be in the form of money or immovable property or even movable property. Thirdly, the society or association should not be for profit or gain. Therefore, in order for the society or association to meet all of these requirements, in the constitution that creates it, the person who creates it must specify that it has perpetual succession, it can own property, and that it is not for profit. However, this is not to say that if the constitution is silent, these things cannot be shown in court if the society or association is sued in order to show that it has a separate legal personality. If the society or association does not have a separate legal personality, then the members are liable similar to those people in a partnership as previously discussed. Although the Societies Act does not provide for the creation of a separate legal personality, the Cooperative Society Act and the Building Societies Act create legal personalities for cooperative societies and building societies. So, if you want your association or society to have a separate legal personality, that is beyond doubt, then they must be registered under the Cooperative Societies Act or the Building Societies Act with the requirements in there that should be met. It is important for this discussion on legal capacity to be understood because legal capacity impacts so many areas of life. And in our videos to come, we will be talking about various court processes. And in dealing with various court processes, legal capacity has a big role to play. Thank you for joining me for this discussion, and please contact your lawyer if you want to know which entity will work best for you, if you want to have someone declared as being of limited capacity as discussed, because these are very important areas of law that have far-reaching consequences and that affect so many people. That being said, thank you for joining me. Please like, share, subscribe, follow me on my social media, and I hope this was an informative discussion, and join me for my next video. Thank you. Bye.